Everyone, welcome to KCAB International Friends Webinar Series. My name is Thang, a case counsel of KCAB International. It is a great pleasure to meet you all as an MC today. This is the 23rd Friends Webinar Series, and title of today's webinar is Construction Dispute in Vietnam. Personally, it is a very interesting subject. I could tell many of you have felt the same way I do, and it is reflected by a large number of registrations as the highest record ever in this series. I'd like to extend our deepest gratitude to our sponsors for their continued support for the success of this webinar. Seoul IDRC, Korean In-House Counsel Association, and In-House Counsel Forum. Our honorable friend being with us today as co-host is not just one, but two, and they are YKVN from Vietnam and Peter and Kim. Both law firms are widely recognized as the leading global firm by providing the highest level of legal expertise for the cross-border transaction or dispute. As they have been closely working together on various cases like in construction project, I hope they deliver deep insight with good chemistry today. All of you might be aware the economic ties between Korea and Vietnam are rooted deeply and is continuing to grow. Such impressive relationship has demonstrated high level of cross-border commercial and trade activities between two countries. And it also extends to large-scale construction projects in Vietnam involving many Korean contractors. In order to continue this active transaction and investment between two countries, it is important not only to understand the characteristics of local market and its legal background in Vietnam, but also to manage a dispute in an efficient way. Particularly considering that both countries have a civil law-based legal structure, there must be some key difference we need to know in order to do business in Vietnam, even if we might have something in common for sure. In this regard, I strongly believe this webinar is timely arranged, and the professionals from YKVN and Peter and Kim are perfect to handle some of the most important legal issues when conducting a construction project in Vietnam. So please enjoy this webinar in that sense, and if you have questions during the webinar, please feel free to use the chat box below the screen and type in your question. Then the speakers will answer them after the panel discussion as much as time allows. Okay, then not to take away your precious time more, please let me call on Steve Kim, the Secretary General of KCAB International, to give his welcome remarks. Steve, the floor is yours.
Thank you very much. Ladies and gentlemen, my name is Steve Kim. I'm the Secretary General of KCAB International. It's a pleasure and an honor to be invited to make this opening remark for this very well attended and important webinar. As Sean have stated in his opening statement, Vietnam remains and will continue to be an important partner for Korea. The number of Korean corporates that are active in the Vietnamese market continues to grow on a per annum basis. And as such, construction industry remains a key factor for both partners here in Korea and for Vietnamese counterparts as well. Construction cases for KCAB International and KCAB in general also counts for the largest caseload fraction of our annual caseload count. Construction industry accounts for over 5% of Vietnamese GDP, which is very significant, and it continues to grow at a very high rate of percentage, over 8%. And it covers a wide range of all of the construction issues and industries that you may expect, whether that may be transportation, water treatment, whether that would be railroad industry, all of those important aspects are covered in that market. And as such, because of the activities, because of the activeness of the market, we do expect to see a number of issues that need to be resolved through an effective and cost-effective measuring where both parties could go ahead and actually resolve their dispute and move forward with their businesses. And parties now have wider range of choices. And in Vietnam, you have VIAC, in Korea, you have KCAB International. And we believe that both VIAC and KCAB have worked closely enough so that we could actually provide a synergistic and more effective and cost-effective ways of actually resolving your dispute. So you could choose either KCAB International to be your administrative body and have your hearings in Vietnam, or vice versa, so that you do not necessarily have to go outside of where you are active in. And we believe it's that type of cooperation and synergy that will continue to demonstrate the level of commitment that both parties have and each country has to one another. KCAB will continue to promote this type of important and thought leadership type of webinar and seminars to bring you the latest set of information and most practical and best practices for your everyday usage for you and for your clients as well. We look forward to continuing working with all of you. I look forward to meeting many of you in person in the near future. And thank you for your time.
Thank you, Steve, for those insightful remarks. Now I will hand over the mic to Mr. Minh from YKVN. And he is a senior partner of YKVN and has more than 30 years of experience in a wide variety of international transaction and arbitration. Minh is a member of KCAB's IAC, also known as International Arbitration Committee. So he gives us extensive consultation on various issues relating to our international cases, and being enlisted as an international arbitrator over KCAB as well. I'm so glad to introduce Minh today. I will be back for the Q&A session after the speaker's presentation. Okay, then Minh, please proceed your presentation from now on.
Thank you, Sean, for your kind introduction. Thank you, Steve. First of all, let me mention what a pleasure and an honor for us to join our friends at KCAB International, as well as our friends at Peter and Kim in presenting this webinar. So without further ado, perhaps I can start with sharing my presentation. Okay. So can everyone see my screen? Hold on, let me do this. Okay, here we go. So real quickly, what I have been asked to do today is to set the stage, or lay the table, if you will, for the discussions, the more detailed discussions that my colleagues from YKVN and Peter and Kim will conduct. My mission is to really talk about the legal framework, the Vietnamese legal framework, as it applies to construction disputes. So a couple of general remarks. The first one is that after 30 years of economic development, since the opening of Vietnam, the Vietnamese legal system has gained clear outline. It is a recognizable civil law system. And what do I mean by that? Well, for example, when the most recent version of the Civil Code was enacted, the Civil Code 2015, one of the key provisions provided that the Civil Code would govern all civil relations. And if you go to the definition of civil relations, you realize that civil relations in Vietnam now cover pretty much everything under the sun, from property relationships to inheritance, succession, to contracts and civil responsibility. I should mention also that for the first time, the Civil Code 2015 introduced the concept of, or the equivalent concept of usufruct, which is a quite civil law concept, into the Vietnamese Civil Code. The other big development what I would like to mention is the increasing role of the courts in the development of the Vietnamese legal system. How has that occurred? Well, the Vietnamese Supreme Court has always provided administrative guidance to the lower courts in resolving cases through Supreme Court resolutions. But about 5 years ago, the decision was taken to have formal precedents designated. And those precedents are usually cases of the Supreme Court or opinions of the Judicial Council of the Supreme Court. The Judicial Council of the Supreme Court consists of all of the justices of the Supreme Court sitting together as a group and reviewing a case on appeal. The discretion, the jurisdiction is completely discretionary, and it is usually triggered by a so-called protest from the chief prosecutor or from the chief justice. So with that, we now have about 57 precedents. Precedents have to be followed by lower courts when they are looking at similar facts. If a court chooses to ignore a precedent, it has to provide a reason for not following the precedent. And so with that, we can see, we are beginning to see the development of a significant body of case law in Vietnam, which I believe will increase over the years. Now, why is that significant in an international arbitration context? Well, it is significant because in international arbitration, we often have panels of international lawyers or lawyers from other jurisdiction, sometimes with very little background in Vietnamese law. So as members of the panel are considering Vietnamese legal issues and arguments, it is difficult for them to reach an informed judgment without materials other than just the plain statute or maybe an administrative guidance from a ministry. Cases, particularly Supreme Court cases, provide that added dimension that will make members of an international panel more comfortable in making a decision or in applying Vietnamese law to resolving a particular dispute. So with that, let me move on to a Supreme Court case, Supreme People's Court case, that in my view has brought a lot of clarity to the area of construction contract disputes. The case is the Minh case, and some of my colleagues will discuss it in greater details in their presentation. For purposes of my presentation, I think it will be sufficient to focus on the one important holding of the Minh case, which is which law applies to a Vietnamese construction contract. And you will see on your screen the exact quote from the opinion of the court. And the court says very clearly that the lower or the first instance court made an error in applying the commercial law to resolving the dispute. It should have applied the civil code. The court cites for that the fact that the construction law is the basis or the basic law when it comes to the construction contract, and the construction contract and the construction law specifies that it is a civil contract, and therefore the Supreme Court reasoned that the Civil Code should apply. It's as simple as that. And while in Vietnam, I think scholars and lawyers are still debating the value of a Supreme Court opinion, which has not been identified or designated as a precedent. But from my perspective, if you are in an international arbitration in front of an international panel, even one which includes one or maybe even two Vietnamese lawyers, and you are able to say that the Vietnamese Supreme Court has stated or has held that a construction contract is a civil contract, and therefore it should be governed by the Civil Code, that is a statement that will go a long way toward carrying your argument, if that is the argument that you're making in front of the panel. So with that, let me move on to just very quickly review the construction law. As you can see, the construction law has been in effect since 2014. There's been some amendment in 2020, but overall, it is still the basic law governing construction contracts, and it provides various procedures that apply in construction activities. It has a section on construction contracts. However, that section is not comprehensive, and we will, talk about some of that. Next slide, please. So if you look at the construction law, there are some features, unique features that we should mention. One, that there are more restrictions on projects funded by public investment or state capital. There are no detailed provisions on contractual breach or liability for contractual breach and damages. And there is a requirement on payment finalization and contract liquidation. This is a procedure in order to settle construction cost as we move on in the construction contract. Next slide, please. In Vietnam, laws are guided by regulations, and these regulations the laws are enacted by the National Assembly. Then the competent ministries will issue regulations to implement those laws. The basic important regulation is Decree 37. Let me just mention that Decree 37 in and of itself applies to projects with requires the use of a FIDIC contract for projects using state capital. However, Decree 37 also encourages others to use the FIDIC form of contract. So in that sense, the FIDIC form of contract is recognized and approved and is part of the legal framework of Vietnamese construction law. Next slide, please. Finally, then, as I mentioned, the construction law does not have provisions about breach of contract and damages, etc. And for that, then we finally go to the Civil Code, since the Supreme Court has told us that we shouldn't go to the commercial law. And in the Civil Code, you will find provisions about liability for damages. And the basic two provisions are Article 360 and Article 419. And you will see on your screen that Article 360 provides that if there are damages due to breach of obligation, the obligor shall compensate for all damages unless otherwise agreed by the parties or provided by law. There is still a fair amount of discussion as to what the scope of this agreement that is permitted under Article 360. But the starting point under the Civil Code with regard to breach of contract has to be Article 419. Next slide, please. And under Article 419 is the basic measure of damages for breach of contract. And you will see that in Article 419.2, damages for breach of contract include essentially the benefit of the bargain plus incidental expenses without any double recovery. I'm sure a lot of people in the audience recognize that the formulation of 419 in its current state will create a fair amount of discussion. There is a lot that needs to be filled in. And indeed, in the international arbitration cases that we've been involved in, we spend a lot of time arguing with the other side about what should or should not be recoverable by way of damages under Article 419. And this is, so I will end my presentation by going back to cases. This is where the increasing number of Vietnamese cases available in the public domain, including Supreme Court cases that have not been designated as precedents, is extremely helpful, because international arbitral tribunals can then look and see at least how Vietnamese courts have resolved similar fact patterns or similar issues that have come before them, really as a matter of reference, not as a matter of binding case precedents or stare decisis. That precedential value is only assigned to 52 cases right now. But to give international arbitral tribunals a great deal more comfort and a broader perspective on the application of Vietnamese law. And that, I think, is a major step forward in promoting more predictable outcome for international arbitration of construction disputes in Vietnam. Thank you. Sean or Steve? Hello?
Okay, thank you, Minh. Okay, so then please move on to next speaker.
Good afternoon, everyone. Can everybody hear me? Following Minh's presentation, I will now discuss about one of the more common, if not the most common issue coming up in most of the construction dispute that we've seen in Vietnam. And the issue that we often seen is the delay liquidated damages in the FIDIC form contract that is governed by Vietnamese law. So what you're seeing on the screen is just a common or standard clause on delay damages in a FIDIC contract. And as Minh mentioned earlier, a FIDIC contract is quite common in Vietnam. And first of all, it's sort of required for contract with a state-funded project, and it's also encouraged in other construction project. So what we've seen is sort of a standard FIDIC delay damages clause. What happened in most of the delay dispute that we've seen is how to interpret or apply this particular provision in sort of a Vietnamese law context. And what we have arrived to is some elements that are quite clear under Vietnamese law, and some of the issues that are not so clear under Vietnamese law that we would like to highlight for your benefit. Next slide, please. So what is clear? Well, what is clear is that FIDIC form contract are encouraged under Vietnamese law, as Minh mentioned, under Decree 37. And under this decree, the FIDIC form is in a way sort of mandatory, and in some other ways is encouraged to be applied for ODA projects. If there's a treaty, and under that treaty, there's a requirement for the use of a FIDIC form contract, then the FIDIC form contract will prevail over Vietnamese law in a way, so that you will apply sort of the four corners of the contract. But what happens if there's no ODA funded project and the party are just use the FIDIC form contract for the project? Now, then we will have to look at Vietnamese law on the issue of breaches or damages. And as Minh mentioned earlier, what we have seen, and is quite clear, is the application of Article 419.2 of the Civil Code. When we have damages caused by contractual breaches, under Article 419, there are only two types of damages. One is benefit of the contract, and the other one is expenses arising from the failure to fulfill contractual obligation without overlapping with the benefit of the contract. So what does that mean? Well, what that means is that there is a certain issue that will come up when we deal with delay damages. And that will lead to a few circumstances when the issue become some sort of ambiguous or unclear to come to arrive to sort of an outcome. Next slide, please. The first issue that we've seen is the question of whether or not the delay damages can be an exclusive remedy. Now, if you're familiar with FIDIC contract, especially the provision on delay damages, you will see that paragraph 2 of clause 8.7, talking about the delay damages, shall be the only damages due from the contractor for the delay, other than in the event of termination by the employer prior to the completion of the work. Well, that would lead to some of the issue here. Next slide, please. So what we've seen is, let's say if there is a delay, but the contract was not terminated, and the dispute end up being resolved by a Vietnamese court or a Vietnamese arbitral tribunal. We've seen some of the unanswered question that would come up. Some examples include, what if the owner did not terminate the contract before the work are completed? Even though the contract, the FIDIC contract specifically provides that the delay damages shall be the only damages. The question would be whether or not the owner still can claim for other damages, such as the expenses to accelerate the work or the loss of income or profits caused by the delay. The question will become whether or not the Vietnamese law, i.e. Article 419.2 of the Civil Code, will prevail over the language of 8.7 of the FIDIC contract. What we also see is another argument from the contractor, i.e. whether the contractor can claim that not only the delay damage is supposed to be exclusive remedy, but the contractor can also claim or may claim that under Vietnamese law, the owner can only claim for actual damages, and therefore the delay damages cannot be greater than the actual damages once proven by the owner. Now that is also a common argument from the contractor. We also see issue in a circumstance that the owner terminate the contract before the work are completed. But then what happened? What can the owner claim? Can the owner claim delay damages under the contract, but also other type of damages? For example, the expenses for fixing or accelerating the work, or the profit loss or income loss caused by the delay. Now, if you go to the next slide, imagine if the dispute is not resolved by a Vietnamese court or a Vietnamese arbitral tribunal, but is resolved by the International Arbitral Tribunal. What happened? How would international law or international common law will consider the issue of delay damages as sort of an exclusive remedy? What we have seen is the view from the UK and the US. Now, in a recent case from the UK, i.e. the Triple Point case, the court there ruled that if the contract is terminated prior to the completion of the work, then the owner can claim the pre-agreed delay damages, i.e. liquidated damages, up to the date of termination. And that would be sort of the exclusive remedy. And thereafter, the owner can seek damages for breach of contract under general law after the date of termination. So it's sort of clearer under the UK case law view, i.e. if the owner terminated the contract, he or she can claim delay or liquidated damages up to the date of termination as sort of an exclusive remedy for the delay. And after the date of termination, any further damages can be sought under general law. Now the US, however, is slightly different from the UK viewpoint. In the McKenzie case, the US court rules that even the contract is terminated, the delay damages claimed by the owner may not be limited to the time up to the termination. The owner can claim liquidated damages even for a reasonable time after the abandonment or termination, i.e. the abandonment by the contractor or the termination by the owner. So this is a slightly different view. Now, unfortunately, there's no clear ruling right now in Vietnam for this issue, and that's why we are leaving it as sort of an unclear issue coming up in the dispute involving delay. Now I'm moving on to a different issue, but also in the context of delay damages, which is the limitation of liability. Next slide, please. Oftentimes, the contractor will claim that because there's an agreed under the contract for the formulation to calculate the delay damages. In common law, the concept is similar to liquidated damages. Now, what happened under the Vietnamese law context? And here we look at it from the construction law perspective and also from the civil code perspective. What you can see on the screen are the citation from the construction law and the civil code. Now, under the construction law, if the contractor failed to perform or perform improperly or incorrectly, and in this case, in the context of delay, meaning that the contractor delayed the contract or the progress, then the contractor must be liable for damages if the owner suffer from such delay, and also liable for other damages if the owner suffer from other damages. However, the level of compensation must equal to the level of losses suffered by the other parties. So what we see here is sort of the concept of the actual type of damages or actual losses suffered by the owner. Now, the civil code have sort of a similar provision where it states that if there are damages due to breach of obligation, and in this context, delay, then the contractor shall compensate for all damages unless otherwise agreed by the parties or provided by law. Now, under the civil code, there's this phrase, unless otherwise agreed by the parties. Now, that creates some argument from both sides. Next slide, please. The owner can argue that delay damages are agreed by the parties and therefore should be allowed under the civil code, meaning that if the parties agree that the delay damages should be 0.1% of the contract value per day, that should be allowed under the civil code without the owner obligation to prove actual damages. The contractor, however, can argue or may argue that even though the delay damages can be agreed by the parties, but the amount of delay damages cannot be greater than the amount of actual losses, looking from the construction law or looking from the civil code, because the contractor is only liable to compensate for all damages, meaning all damages suffered by the owner, but not more. From that perspective, then the contractor can argue that the owner, first and foremost, must prove the amount of actual damages is suffered. And after that, if such amount is smaller than the agreed delay damages, then the owner can only recover up to the actual damages, not more. Now, if the actual damages is actually greater than the agreed delay damages, then the owner can only recover up to the delay damages amount. So in either way, you have to choose the lesser of the two amounts. That's the argument from the contractor. So as you can see, on this issue alone, there are possible arguments from both sides. And the definite answer here is not clear. And we're using this presentation to highlight to you some of the area or arguments that we've seen in construction disputes, especially when it comes to delay damages in Vietnam. That ends my presentation. Thank you very much.
Many thanks to YKVN For the insightful presentation, it was a good chance to learn about the general background in construction dispute in Vietnam and what is the important legal issue in construction projects under Vietnamese laws. Now I will invite the professionals from Peter and Kim, so they will handle the contents in terms of arbitration in the perspective that what we need to know in order to handle the construction dispute in efficient way. So Tran will present regarding the arbitral framework in Vietnam, and Mino will handle the key difference of general arbitral environment between two countries in a row. So I will be back after Mino's presentation.
So hi everyone, and thank you to the KCAB for hosting us today, and to our colleagues of YKVN for the collaboration on today's event. So you've just heard from our colleagues and friends from YKVN about aspects of Vietnamese substantive construction law, which is of particular interest to the audience, I believe. And now Mino and I will focus more on procedural aspects of resolving construction disputes through arbitration in Vietnam. Since time is limited, I have tried to identify a few of the most striking differences between the Korean Arbitration Act, to which some of you may be more familiar, and which is a more classical arbitration law that follows pretty squarely the UNCITRAL model arbitration law of 2006. And those are the provisions and the differences that I think are worth looking at very carefully if you have an arbitration sitting in Vietnam. That being said, before starting, I'm sharing a few references on the legal framework for your arbitration seated in Vietnam. And I repeat the advice that I think it's important if you have an arbitration in Vietnam to carefully review actually the whole arbitration law, because it departs sometimes significantly from more classical arbitration laws, so that provisions may not come to you as a surprise. This is important to read the law of the seat, especially in the case of Vietnam, carefully together with the arbitration rules. So now one of the first noticeable differences that I will speak about is the fact that the law on commercial arbitration of Vietnam of 2010 provides for qualifications of arbitrators, which is a condition that is not found in the Korean Arbitration Act. To the contrary, the Korean Arbitration Act follows the UNCITRAL model law and states that the parties may actually agree to exclude arbitrators of certain nationalities, but there is no specific positive requirements, such as the one in Article 20 of the LCA, which adds the requirement of having full legal capacity, which is somewhat expected, but also of having a university qualification and at least 5 years experience in that area. And but there is an exception if you have equivalent expertise through other means. And importantly, in any event, a person cannot act as an arbitrator if they are currently not only a judge, but also a prosecutor, investigator, enforcement officer, official of a people's court, or of a people's procuracy, investigative agency, or of a judgment enforcement agency. And also persons under criminal charges or prosecution, or persons who have served their sentence but have not yet had their criminal record cleared, are not eligible to become arbitrators. So these are requirements that you may think, oh, my arbitrator is not gonna have this kind of issue, but those are actually to be checked, because it may be poison in the follow-up of your arbitration if these requirements are not fulfilled And later on, you have a challenge of your arbitrator or a challenge of the award based on that. So I note that in Korea, current judges are also precluded from acting as arbitrator, but this is much more narrow than Article 2A here, 22A. Now, there are also differences in the grounds for challenge of arbitrators, and they are to be noted also actually when you will constitute the tribunal to avoid, to anticipate on possible challenges. And you see that in the Korean Arbitration Act, Article 12.2 is pretty classical because it's not very specific. It just states that the grounds for challenges are basically circumstances likely to give rise to justifiable doubts as to the impartiality and or independence of the arbitrator. Very classical, not very explanatory. The Vietnamese law, for its part, goes much further, and in general, the law on commercial arbitration goes into more details. It covers more areas than commonly encountered arbitration laws. And on this, on the ground for challenges, you must also care that the arbitrator is not a relative at all to one of the relative or the representative of a party, that he has no interest in the dispute. This is pretty classical, but also the requirement of to be impartial and objective is also classical, but you also have Article 42.1d, which says that the arbitrator who was a mediator, representative, or lawyer for either of the parties prior to the dispute being brought to arbitration cannot act as an arbitrator. Can be challenged on that ground. So this is important because it goes further than the usual standard, that we use for checking these sort of conflicts, in the sense that here we don't even have like a limitation of period. So it can be prior to the dispute, but maybe 10 years before. So this is something that you should be careful about at the time of the constitution of the tribunal. Now, there is also a difference that struck me between the Korean Arbitration Act and the LCA, the Law on Commercial Arbitration, is that the Korean Arbitration Act and the LCA contemplate the situation in which the parties reach a settlement agreement during the arbitration proceedings. This is very good for the parties usually. But the Korean Arbitration Act only deals with what happens in the arbitration proceedings if there is a settlement and there is the possibility for the parties to request an award by consent or an award on agreed terms, as we call them. This is essentially like the award recording the settlement agreement that the parties have on their own negotiated and agreed. There is not in the Korean arbitration a very strong incentive for the parties to actually pause and negotiate during the arbitration proceedings. To the contrary, the LCA actually provides for the possibility for the parties to the arbitration to request a mediation by the arbitral tribunal. So I think it's interesting to see how in Vietnamese arbitration law, the mediation is fully integrated in the process at Article 9 and Article 38. And actually the end of the arbitration proceedings in such a situation, it's the same. The parties can request that an award by consent be issued by the tribunal, but this contemplates the situation in which a tribunal itself has conducted the mediation. So we could discuss a lot about this because this is very interesting how the jurisdiction in general vary on this, on the liberty for the tribunal to try to facilitate settlements between the parties. At the end of the day, they know the dispute at some point. If they have an opportunity to try to get the parties closer, this is usually to the benefit of the parties. That being said, there are still a lot of debates on whether the arbitral tribunal itself should do it, because if the settlement sessions and the mediation doesn't work, the parties go back to the arbitration proceedings, sometimes having a pretty clear idea of what the tribunal likes and doesn't like in the arguments, and so on, or even what he thinks about the the outcome of the possible outcome of the proceedings. So it is a bit of a tricky issue, but this is in general very interesting to see how fully integrated it is in the LCA. Now, turning to confidentiality, I won't be long because it's just that the Korean Arbitration Act does not provide for confidentiality of the arbitration proceedings. Often people assume that arbitration proceedings are confidential. This is not always the case. Of course, there are the legal obligations to disclose sometimes, but beyond that, there are a lot of arbitration laws, like the Korean Arbitration Law, that do not provide for such obligation. To the contrary, the law on commercial arbitration does provide for confidentiality of the proceedings. I, however, note that there are the rules of arbitration sometimes provide for it, and actually the KCAB arbitration rules, both domestic and international, provide for confidentiality of the arbitration proceedings. Now, I turn to a discussion on the enforcement of arbitral award in Vietnam. This is a crucial issue, if not the only one that matters at the end, enforcement. And so as from here, I will not necessarily compare the two laws, but rather try to give you some practical insight on the practice of enforcement of arbitral awards in Vietnam. And this is really thanks to the input of Minh and Nguyen, who have a long-standing practice of the LCA and have shared their perspective. So the start of the discussion and the explanation is that in the LCA, unlike arbitration laws in many other jurisdictions, there is not the distinction between domestic and international arbitrations. There is the distinction between foreign versus non-foreign awards and arbitrations. So what is the criterion? The criterion is in Article 311 of the LCA, which provides that foreign arbitration means arbitration established under the provisions of foreign arbitration law as agreed by the parties to resolve the disputes, whether inside or outside the territory of Vietnam. So I don't know what will be the view of arbitration practitioners with us, but this is very, very vague, very, very blurry. What does it mean? Because it obviously leaves a lot of room for interpretation. And actually, so if you have an arbitration seated in Vietnam, but that is governed by conducted under the KCAB arbitration rules, it could be considered as a foreign arbitration. So we will see what to do with this distinction and this difficulty. Why? Because when it comes to enforcement, the law regarding the recognition and enforcement of the award is going to be different depending on whether the award was foreign or non-foreign. So you see the importance of the criteria and the vagueness of the criteria we've just seen. So this is really an issue because non-foreign awards are automatically recognized as would be civil judgments. So you can go directly to the civil judgment enforcement machinery, and to the contrary, foreign awards must be recognized before by the local courts before you can seek enforcement in Vietnam. So to this, you add, for those who are not familiar with that, the context that in Vietnam, the case law relating to the recognition and enforcement of awards is admittedly still today uneven and inconsistent. So on this, this is really on even the Supreme People's Court and the Ministry of Justice who have recognized in public fora that there is an issue of consistency that is largely due to the fact that the courts located throughout the country do not have the same experience and the same exposure to enforcement issues. So accordingly, I mean, at the moment in these recent years, there have been a lot of concrete actions taken by the government to tackle this problem. And notably, since 2020, there is a database where you can consult summaries of decisions of Vietnamese courts on enforcement, and recognition and enforcement, but you also have most importantly, a draft resolution of the Judicial Council of the Supreme People's Court at the moment that is aiming at providing the uniform guidelines to all Vietnamese courts to apply when they are considering enforcement and recognition issues. I understand that this is, I mean, I think it's still in consultation right now because with the pandemic, it had been a bit interrupted, the consultation. But our colleagues from YKVN think this will be a major step in the development, the improvement of the arbitration context in Vietnam and for the predictability of your arbitration when it's seated in Vietnam. And why? Because of the definition of foreign arbitral awards will be much closer to the one in the New York Convention, and because this resolution would have the force of law and would be an effective guide to the lower courts, an instruction to the lower courts on how they have to interpret this foreign arbitration criterion. So now that you have the context that is difficult to enforce awards in Vietnam, I will share a strategic perspective that is again, like, thanks to the input of Minh and Nguyen. So because today there is still a lack of predictability. So what can you do? Let's assume that you are a Korean company contracting with a state-related Vietnamese entity, and negotiations may lead you to have the seat in Vietnam, even if you have a KCAB arbitration rules, and the arbitration may have other foreign elements. So let's assume that you win the arbitration and that you want to enforce the award, and the assets are primarily located in Vietnam. So the definition of foreign arbitration is vague, but and it's tricky to actually even answer yourself to the question whether it's foreign or non-foreign. So the insider tip from Minh and Nguyen, who benefit from a long-standing practice of the ACIA, is to take it as an option for the winning party to choose to treat the award as foreign or non-foreign. So you can file an application for leave to enforce the award that you consider as a non-foreign award with the state enforcement agency if your counterparty has not enforced it within the time limit. Or you can file an application for the recognition of the foreign, what you consider as a foreign award, with the competent provincial people's court, and later seek enforcement of the decision, holding it enforceable. So it's sort of a one-shot deal, because if you file with the state enforcement agency, you take the risk that the courts decide upon objection of your counterparty that no, this is a foreign award that must be first recognized before it can be enforced. But this is to balance with the fact that the statistics show a much higher rate of enforcement of domestic awards, non-foreign awards, as compared to the rate of enforcement of foreign awards. So this is a strategic decision to take, and it's an insider tip that you can use, because we've seen also on the substantive law that sometimes you have gaps, or more like provisions that leave a lot of room to interpretation, and in this case there is room for strategy. I think I'm getting close to the end of my time, but I'm sharing the last slides is a summary kind of the different time limitations that apply at the end of the arbitration, but also at the beginning of the arbitration. And this is also something that struck me in the LCA, is that it contains actually a substantive limitation period to initiate your arbitration. So, it probably accumulates with other statutes of limitation from the substantive law applicable. And on this, I will just leave you the references, but I will add that as soon as we speak about limitation periods, there is this issue of whether it's procedural, it's substantive that comes. And in the context of international arbitration, it's hugely important to know what the tribunal is going to treat the statute of limitation as. Is it procedural or substantive, because if he decides that it's procedural, and he might apply the law of the seat as opposed to the law of the contract, and this might come as a surprise to the parties. We may discuss this more in the Q&A, but otherwise, for my part, this ends my presentation. Thank you.
Mino, please go ahead.
I think someone has to turn my video on. All right. Thank you. Thank you. Thank you, Hoang, for your presentation. You have explained to us the framework, the legal framework of arbitration in Vietnam and in Korea. What I was trying to do in my 5 to 10 minutes is to bring you actually to Vietnam or to Korea and take you to an arbitration travel, how it is actually to do an arbitration in those jurisdictions. And is there really a difference between the two jurisdictions, or is it rather a nuance and it's actually closer and more similar than it looks at first glance? Before I do that, I was trying to give you a snapshot of the statistics of the KCAB and VIAC to give you a flavor of what is arbitration in that jurisdiction and how is it perceived actually. How many cases is the KCAB and VIAC dealing with, especially international cases, which reflects how experienced they are with international cases and how reliable they can be. The KCAB shows a caseload consistently of 400 plus minus cases, 70 to 80 of them being international cases, whereas the VIAC has about 46 international cases in the statistics for 2020. So that's sort of the current address of these two institutions. It's quite active. Interestingly, the industry sectors that are dominant in these institutions slightly different. You can see that in the KCAB, more than a third of disputes is about construction. And on the one hand, it's because the construction industry in Korea is big. But also on the other hand, you can think about Korean standard form contracts, which mandate KCAB arbitration and shows if the government or if an industry pushes for an institution that increases the number of disputes in that sector. Trade and IT are followed. VIAC, on the other hand, has a dominant caseload of sale of goods disputes, which I found very interesting. And international trade is a big part of the Vietnamese industry, hence sale of goods unsurprising. What is different? Or I might change the question, is there any real difference? And to give you the quick answer before sliding through all the slides, no, there isn't. It's actually more similar than you think it is. The default number of arbitrators looks different because the KCAB rule says the default number of arbitrators is 1 unless agreed otherwise. VIAC starts with 3, again, unless the parties agree otherwise. In practice, very often the parties put into the contract that the number of arbitrators should be 3 or they otherwise agree. So it happens that in reality, it's not that different than you think it is. What about the grounds for challenging an arbitrator? As Hoang has explained to us, the KCAB rules and the VIAC rules effectively reflect what the relevant arbitration laws are saying. And hence, the KCAB rules are more abstract. They say, in sort of broad terms, If there are justifiable doubts as to the arbitrator's impartiality or independence, that's a ground for challenging an arbitrator. The VIAC rules are much more specific and concrete, including if you're a relative or a representative of a party, you can be challenged. Consolidation of claims in arbitration proceedings is available under both rules. It's a modern feature, consolidation of claims, joinder, expedited proceedings is sort of a feature of modern international arbitration rules, and both rules have it. The KCAB has a little bit more detailed provisions, and I'm not going into them now, but both features are available. What about case management? And for pausing here for a second, if you are promoting arbitration in a jurisdiction and you are an emerging jurisdiction, you want to have an appeal, you want to sell, what can you sell? Cost efficiency, you're cheaper than the ICC, for instance. Time efficiency, you're very efficient. And reliability, you are as good as the other institutions. And you have all the modern features. I think it's about cost, time, reliability is sort of the quality aspect, and having all the features that other rules do have as well. And case management concerns time efficiency. So the KCAB rules has express provisions about bifurcating proceedings if necessary, and allows the tribunal with a wide discretion for structuring the arbitral proceedings. The VIAC rules do not have a specific provision for bifurcation, but however, it's generally understood that it's possible and also allowable. In similar vein, scheduling is very important to run an arbitration time efficiently, and both the KCAB rules and the VIAC rules mandate that a case should be run efficiently. So scheduling procedural timetables is a very similar feature, I would say. Arbitral award, it goes again alongside the theme speed. KCAB says final award within 45 days from the date of final submissions or hearings. VIAC says within 30 days from the date on which the final hearing finishes. In practice, these deadlines are, in our experience, often extended, but it shows the willingness or sort of the intention of the rules to run a proceeding time efficiently. Expedited procedure, again, it's a modern feature in many arbitration rules, and following that, the KCAB rules and the VIAC rules both have provisions on expedited proceedings. One small difference is that the KCAB rules have more detailed provisions, especially an expedited procedure is also applicable even if the parties haven't agreed upon expedited procedure, if the claim amount is small enough. So it's really an additional availability. It's an additional option under the KCAB rules to run your case expeditiously. What about the cost efficiency aspect? Both the KCAB and VIAC emphasize and require parties to run a case cost efficiently. In addition to that, they have common features to advance arbitration costs and deposit it at the beginning of the case, similar. So I've done a simulation. What would be the approximate arbitration cost according to the cost calculator under both rules, and I've taken a random number, say $10 million, and put it into the calculator. And interestingly, the KCAB cost calculator came up with $50 to 100,000, excluding filing fees and arbitrators' expenses. The VIAC calculator said something similar, but on the higher end, $97,000 approximately. I was curious, what would the range be if I increase the dispute amount 10 times? And this is what I got. KCAB rules, or the KCAB calculator, said $245,000 to 345,000 USD. Again, it's an approximate sort of estimate, but it shows where the costs might be. Whereas VIAC calculator said approximately USD 390,000 if the claim amount is 100 million USD. Finally, before I close my presentation today, a quick word about mediation. I found it interesting that the VIAC rules provided mention of mediation, especially MEDAP or ARB-MEDAP, where you switch from arbitration to mediation or vice versa. And found it interesting that in the rules there was express sort of mention of mediation. That's what I have in my slides. This, the quick snapshot of the two institutional rules, and I'm happy to address any questions that you may have. All right. Sang-Yeop? I was told that I can lead the Q&A session. One question I had to Nguyen about delay damages in Vietnam. In Korea, we have an express provision in the Korean Civil Code saying a judge or a court may deduct liquidated damages if they are deemed excessive, and they have discretion to do so. And I understand from experience that the Swiss Civil Code, the Code of Obligations, also has a provision on good faith, and in the industry that provision is relied on to claim a deduction of LDs if they are excessive. And I was wondering, in addition to what you explained today, whether there is anything like that in Vietnamese statutes or case law or practice.
Thank you, Mino. The short answer is no. First of all, we don't have a similar provision in which the judge or the tribunal would adjust down if they deem that it's excessive. Normally, let's say a court in Vietnam, or let's say an all Vietnamese panel in an arbitration may consider the actual damages. So they will look at the actual damages suffered by one party, and they will use that as sort of the benchmark, as I mentioned earlier in my presentation. Sometimes the court will say, the party suffer from the damages can only claim up to the actual amount, but not more.
Thank you. One question from the audience that I'm picking up is about delay penalties as opposed to delay liquidated damages, and was wondering whether you could share a quick word or reaction as to penalties under Vietnamese law.
Yes, I believe the question is that he or she was wondering whether or not the parties should amend the delay damages provision under a FIDIC standard or FIDIC form contract to say, to change it become a delay penalty, and whether or not is necessary or preferred. Now, under Vietnamese law, there are two different regimes. One is for damages and the other one's for penalties. So you need to understand that there are two separate regimes. Damages are damages and penalties are penalties. There's some restriction under penalty. For example, under the commercial law, a penalty cannot go above 8% of the portion of the contract being breached. Under the construction law, in construction contracts that use or involve state funding, then that cap go to 12%. So you have to take that into account when it comes to penalty. The parties, however, are free to agree to amend a FIDIC form contract to have a delay penalty clause instead of a delay damages clause, but should take into account the Vietnamese law penalty regime and also the relevant restrictions therein. I also want to note that under the civil code, if the parties agree on a penalty clause, but do not say anything about the general damages, then the non-breaching party can only claim for the penalty. Now, if the parties want to have both penalties and general damages, then they have to specify in the contract that in addition to the penalty, the non-breaching party can also claim for other damages or damages. So I hope that that would answer the question.
Yes, we got a follow-up question from the audience, and see that the audience is highly interested in delay damages clauses, which is a question actually that I had in my mind as well. If the employer can only claim the lesser of actual damages versus liquidated damages, meaning if the amount of actual damages is lower than the amount of liquidated damages, then why do you have an LD clause? What's the function or what's the utility of it? Is sort of a quick reaction one might have.
Yeah, first I have to clarify that under a FIDIC form contract, the term or the caption or the subject line is not liquidated damages. It just said delay damages. Vietnamese law do not have the concept of liquidated damages. So what we're talking about is a clause on delay damages, which the party agree on. Now, if you have the dispute to enforce the delay damages clause in front of the court may ask the claimant or the plaintiff to prove the actual damages amount. And then the court will say, okay, under the civil code, i.e. Article 360 that Minh mentioned earlier in his presentation, the parties have agreed on a delay damages calculation. If the delay damages calculation is lesser than the actual damages, then that will act as a cap. Now, however, if the delay damages calculation goes beyond the actual damages, the court may say that you may not be benefited from such clause if you only suffer the actual damages amount. So the breaching party should only compensate for the actual damages amount, but not more. It's unfortunate that the FIDIC standard form is a standard form, so it cannot cover all jurisdiction. And therefore, we will always suggest our client to take into account the Vietnamese law regime, and in some circumstances should clarify or should amend accordingly, even when they use the FIDIC standard contract form, so that if there's disputes arising from the contract and Vietnamese law is governing law, the rights of the parties should, I mean, at least the contract is, or certain provision in the contract can be enforced under Vietnamese law.
That's very helpful. And if I understood correctly what you explained, correct me if I'm wrong, an employer can enforce an LD provision, LDs against the contractor, but if they go to court and the contractor proves actual damages and the amount of actual damages happens to be very low, then there's a possibility that the court says you only get the actual damages. Sort of, it sounded to me in a way similar to an adjustment mechanism, ultimately, sort of, but and hence an LD provision is still of utility because you could primarily enforce it.
Yeah, in a way, if you have sort of a delay damages standard provision, but the other side or the court requested, and the employer can only prove up to a certain amount of actual damages. I think what we have seen so far in the case law of Vietnam is that the court were likely to cap it at the actual damages amount.
Perhaps we have time for one more procedural question for Hoang from the audience. See in the chat box a question saying, did I understand correctly that the strategy for enforcing an arbitral award in Vietnam is to file applications simultaneously in both state enforcement agency to enforce non-foreign and recognition of foreign awards? Hoang, would you like to address this before we close today's event, or Minh, or who would like to share the wisdom on this question?
Sure. Hoang, should I take this one?
Sure.
Okay. I think what we are saying is that a foreign party who obtains a favorable award in a Vietnam-seated arbitration governed by rules of an organization or rules that are not Vietnamese rules. So could be UNCITRAL, could be ICC, could be KCAB. That party has a choice of either treating that award as a domestic award and proceeding directly to enforcement, or treating that award as a foreign award and proceeding to enforcement through the New York Convention mechanism that have been codified in the Vietnamese Code of Civil Procedure. Now, what's the difference between the two? Well, if you go for the domestic enforcement, you can go to direct enforcement. However, there's a catch. The catch is that the other party, presumably the Vietnamese party, can appeal to a Vietnamese court to set aside the award. And if the award is set aside, then that judgment is final. And so if your award is set aside, you've just lost the case. On the other hand, if you proceed under the New York Convention or the Vietnamese codified version of the New York Convention, you have the right to appeal. If the lower court denies recognition and enforcement, you can appeal to the next level of court. So depending on the facts and circumstances of the case, there may be one alternative which is more viable than the other. The advantage is it is not a decision you have to necessarily make up front, but you can make that decision at the point at which you obtain an award.
Thank you. Sean or Steve, was wondering whether you would want to close the session.
Okay, sure. Thank you for very this informative presentation. I apologize for my sudden disappearance due to technical issue. Actually, we were planning to limit the time by 70 to 80 minutes, but couldn't stop your high interest towards this webinar. So if there are some audiences who couldn't ask or missed a chance to ask, then please send an email to the panelists. Then I believe they will gladly reply back to you. Okay, then. All right, so I think we already passed the expected end time, so it's time to wrap up. It was very interesting to hear all your candid views, and this webinar will be uploaded later on KCAB International YouTube channel. So the recording link and the speaker's presentation slides in PDF format will be sent out to the attendees. So please check later if you missed some moments of the webinar. And our next webinar will take place soon, maybe next week. So we hope you keep interested with our Friends webinar series and hope to see you there. In the meantime, a big thank you to our panelists for taking your precious time to join us today. Okay, then it's time to say goodbye. Okay, everyone, thank you very much. Take care.
Thank
Bye.
you.
Thank you.
Bye-bye.